Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly, every other week, telephone call for the community. You would have heard the disclaimers as you logged in. Those disclaimers apply. That said, let's just make a quick sound check, make sure you guys can hear me okay.
The conference is now in conversation mode.
Can you guys hear me all right, folks? Can you hear me?
Yes.
Okay,
Yes.
excellent. Thank you.
Yes.
The conference is now in presentation mode.
Okay, I'll go through the frequently asked questions first, and then I'll start with the non-frequently asked questions. Today I have a very busy roster. I usually like to stop at 14 questions. Today we have 19. So we're not going to have time for new questions. I'm going to do the best with questions that we have posted already. And by the way, there's one question about political asylum, and I've mentioned it earlier. My knowledge of political asylum is close to zero, so I will not be able to answer that question. Sorry about that. Our first frequently asked question today is, so this is from Bhanu Arora. I'm currently on H-1B, I-140 approved in EB2. I want to know if I can change my employer and retain my priority date. So I've mentioned this before a couple of times in our conferences. Under the 2017 regulations, you are entitled to keep your priority date the moment the I-140 is approved. There is absolutely no two ways about that. Unless the I-140 is revoked for some kind of fraud or egregious error on part of the USCIS, you keep your priority date the moment the I-140 is approved. In addition, if you stay with the employer for 180 days, you get to keep the right to extend your H-1 through any employer. So let me rephrase that. It's not really that you have to stay with that employer. Further down, there is a question about that. You don't have to stay with the employer. Just the I-140 must stay approved for 180 days. If they revoke the I-140 181st day after the approval, no problem. You carry the right to extend your H-1 beyond 6 years with any employer and your wife's H-4 EAD. So once again, the priority date is yours the moment the I-140 is approved, whether it is revoked the very next day. But if it stays unrevoked for 180 days, whether or not you're with the same employer, you also carry forward the right to extend yours and your wife's employment authorization. In your case, it is the H-1B. Okay. Any follow-up questions on this? Star 5, please. Any follow-up question? Press star 5. Oh yeah, one more thing in this. Do I need an original I-140? And the answer is you really do not. Even having a copy is enough. We've also done it sometimes with just the name of the employer and the name of the employee. And that has worked out as well. So we have a question from area code 469. 469, where are you calling from? Hello?
Hi, sir. This is Anu here. So I just posted the first question that you were talking about. So I think I just wanted to know.
Ma'am, where are you calling from? I always like to know that. Where are you calling from?
Dallas, Texas.
Dallas, Texas. Okay. Haji Banu, go ahead.
So, do I need to get the original I-140 because my employer is not ready to give that to me, and they're saying maybe you should just use the petition number?
No. I have just answered that question. We've had to make it work even with sometimes just the name of the employer and the employee. And if you have the petition number, that's better. But I would advise you to do something, Banu. I think you should go ahead and file a Freedom of Information Act request, actually more accurately, Privacy Act request. File that online. It's called Freedom of Information Act request, and get a copy of all your documents. You should have a copy anyway.
All right, I will do that. Thank you so much, sir.
You're welcome. Good luck.
Thanks.
Okay, there's another one from area code 972. 972, go ahead, please.
Hi, Khanna ji. This is Deep from the Dallas.
Yes, sir.
And I have a similar question. So if 140 is approved and if we change the employer, so do we know, it's almost 3 years now. So do we know, we don't need the new green card need to be filed, or we can use the same 140?
No, that's a different question. You do need to refile the green card. Having an I-140 approval doesn't give you a green card under EB2 or EB3 category unless you are a national interest waiver case. So yeah, basically you do have to restart the green card.
So but restarting the green card will take almost a year, entire process. So in that case, if our H1 and H4 is getting expired, do we have to wait for the new green card 140 to be approved? Or from the...
No, you get the extensions based upon the old I-140 approval.
Okay, so as long as we have 140 copy, old 140 copy through any employer, we can extend our H1 as well as the H-4 EAD.
As long as the I-140 stayed unrevoked for at least 180 days, and at least one of those 180 days was on January 17th, 2017. If your I-140 was revoked before that, that's a different law. Okay?
It's 3 years now from today. It should be
well, January 17, 2017, do the math, you should be okay.
Yeah.
Okay, sorry, I mistakenly dropped you. If you have a question, I'm sorry, I just dropped you by mistake. Press *5 if you have any follow-up questions. I don't know if you did. Press *5 again. Okay. Oh no, this is a different person. This is New York, it looks like. 212, go ahead.
Yes, sir. I just want to know if my I-140 is approved in 2011, then what is the scenario for that?
I don't know what you mean by what is the scenario. Was it revoked?
Yeah.
Was the I-140 ever revoked?
No, it's not even.
Well, then
No.
you have the priority date of 2012 and you have the right to keep extending your H1 with any employer. Okay.
Okay.
Yeah.
Okay.
How old is it? It doesn't matter. As long as it was over 180 days unrevoked and at least one of the days falls on January 17th, 2017. In your case, it has been unapproved forever. So, I mean, unrevoked forever. So obviously you have all the benefit. Okay.
Okay.
Yeah,
okay,
you do have to start your green card again, but you will carry the priority date of 2012.
Oh.
Okay.
Okay. Okay. Thank you.
You're welcome. Okay. Let's go on to the next question. Next frequently asked question. And this is actually the same series. I should have combined these two, and maybe I can do it now. Because this is basically the same question from Bhanu and Harshada. Let's just merge these posts. So I'm just going to merge these posts because they are essentially the same question. So I answered that question already. You don't have to stay with the same employer. It is just that your I-140 should stay unrevoked for 180 days. And you can still use your I-140 priority date is yours the moment your I-140 is approved. That has nothing to do with the 180-day time. Okay. I think I have covered everything in these two questions. *5 if you have a follow-up question. *5. All right. Let's go on to the next frequently asked question. And these are again, I combined two, one from Anu, one from Aurora. Aurora has a fairly lengthy email posting. I'm not sure I can cover all that. That's a whole lot of material. I'll do the best I can in the time that we do have. So this is happening quite frequently, and I think it's an important frequently asked question. This will require some explaining and some understanding. So if you have a green card holder, you're a green card holder or your parents are green card holders, and they get stuck outside the United States, they either cannot or you don't want them to travel on their during the pandemic, and their 1 year is about to expire or has expired. What happens then? Well, under the law, once you have been outside USA for 1 year, your green card is no longer available. It's gone. What should you do? You would probably, first of all, you can always apply for a green card again. So if you are the parent of a US citizen, they can apply for you again, but it'll be a new green card. The second option is something called an SB1. S as in Sam, B as in boy. SB1 visa, also called returning resident permit. Okay. In that, you have to convince the consulate that the stay outside the United States was because of circumstances beyond your control. You got stuck in it. And I think even having a medical condition or a relatively advanced age can be, or it should be taken by the government to be a good explanation. So far, we have not heard anything from the government giving us definitive guidelines on how to proceed on these cases. Okay, so when you apply for SB1, it is basically done at the consulate. The details are available on their website, also on in the State Department Standard Operating Procedures, which are contained in a publication called Foreign Affairs Manual. Foreign Affairs Manual. So if you Google Foreign Affairs Manual and go to volume 9, in volume 9 has all the immigration stuff, and if I remember correctly, the SB1 is somewhere around 501, 502, section 500, somewhere in that area. So you can read up on it, but that appears to be the only option if you want to reinstate the green card. So either reapply or reinstate through SB1. When should you file the SB1? I would say about 3 or 4 months before you want to travel, because it will take them that much time to process the SB1, and there will be a personal interview for that. Okay. Now, if there is an emergency, like in case of Anu, health conditions, not able to travel back before the expiration, what are the options for avoiding the expiry of the green card? There really isn't any. Is there a 60-day extension of the expiration? There isn't. So what I would do is I would try to get in touch with the consulate, send them emails, etc., asking them their guidance. And that way you have at least some proof that you tried to get back into USA on time. But if it goes past 1 year, it goes past 1 year. It can't be helped. You can always start a new green card if you like. Not too many options here. *5 if you have a follow-up question on this. *5. Okay. This is from area code 414. Where are you calling from, 414?
Wisconsin.
Yes, ma'am. Wisconsin. Go ahead.
So you mentioned that maybe we can send an email to the consulate. Right. So would that be like, because we're Wisconsin, like would that be the consulate in India or the consulate here in
India? There is no consulate in USA. It will have to be in India. Whichever consulate your father would go to normally, Chennai or Mumbai, wherever he goes to normally, just send an email to them and say, this is our situation. What would you like us to do?
Sure. Thank you.
Good luck. Okay. Let's go on to the second from Aurora. So again, the same situation, stuck outside. I'm in my early 60s, homeowner for 30 years, no business accounts outside the US. So I'm definitely a resident here. Home is always available, but it was rented 1 bedroom. Something about taxes, no taxes due. Most trips outside were 5 months, 3 months or less. One trip was 8 months for unplanned health reasons. Okay. But now in December, it will exceed 12 months. And same answer for you. You are stuck in Philippines. I would say that go ahead and try sending keep track of your emails and communications with the consulate. If tomorrow things don't work out, at least you have an argument that you tried your very best. Return home in June 2021, parent my daughter for the summer and face the stress of defending LPR. Well, I think you should, like I said earlier, you should definitely try for the returning resident permit, the SB1. And people are traveling. I know that I wouldn't want to if I had a choice, but it definitely, the stress level is a lot lesser in terms of protecting your green card if you fly in earlier. But if you don't want to, or if you have a medical reason not to, or even a personal choice, be prepared to fight this out. And the problem is, when you have exceeded 12 months, or you have reached 12 months of stay outside, the airline will not let you board the plane. So you can't even come to the US border. Okay? Yeah, you won't even be able to come to the US border. So your situation is different. Under the rules, if I don't remember exactly how the admission rules work, but I know that if you try to fly out from Philippines, for example, the airline should stop you boarding. But if I remember correctly, if you come to the border at the airport and you present your green card, even if you have been outside USA for 1 year, more than 1 year, they have to let you in. They'll put you in deportation, in removal proceedings, but that doesn't mean that you can't come in. This is what I remember. You'll have to double check this, because this is a situation in which we don't find ourselves quite frequently. So we've dealt with it before, but I don't remember what the outcome was. If I remember correctly, if you are able to make it to the airport, they have to let you in if you have a green card, but they'll place you in proceedings. *5 if you have a follow-up question, *5. Okay. So, do we have any other frequently asked questions? Okay, we do not. Let's go on. People who are just logging in, folks, we're not going to have time for new questions today. Sorry. Only the posted questions. Okay, now going back to the first question. These two we covered. This is now question number 3. Presently in GC, EAD and EB2 petition of a different employer, supplement J approved, pending 485 with current employer. Also have EB3 petition from past employer 10 years ago. EB2 and EB3 dates are current. USCIS revoked EB3 as inability to pay. That should be challenged. Appeals to AAO are very, very rarely successful. So you're just still stuck with the green card. I think that you should definitely consult counsel to see if you have any possibility of a lawsuit, because I see a few things wrong with this. First, if your EB3 was approved, looks like 10 years ago, can they now go back and revoke your I-140? I don't know. I certainly hope there is an argument against it. I think there should be, but I understand that the regulations do require your employer to maintain ability to pay wages till the green card is approved. However, there's something quite wrong with having to wait 10, 11, 12 years to confront this issue. So I think that can be challenged. But if your dates are current under both, then you can let the EB3 slide. I don't see any problem with that. So next step is you should definitely have a consultation with your lawyers and see if it is possible for you to file a lawsuit to hurry this thing along, because your dates are current and they're not acting on it, and there appears to be a lot of suspense surrounding your EB3 I-140 revocation. Don't know your whole case, but this is what it looks like to me. *5 if you have a follow-up question. *5. Okay, this is area code 425. Where are you calling from, 425?
Hi, sir. This is Neha. I'm calling from Seattle.
Yes, ma'am. Yeah, Neha.
So this is my question on while we are talking with USCIS officers, they are saying EB3 is under AAO and we cannot proceed with your current date with EB2, even though our dates are current.
Okay, let's take a step back for a moment.
Yeah.
You had filed, basically your EB2 date is not 2009. It's your EB3 date that's 2009, right?
That is correct.
Okay.
Reported to EB2.
Okay. So when did they revoke the I-140, the EB3 I-140?
2019.
Okay. Is there a particular reason why you chose to file an appeal rather than just file a lawsuit?
So the reason is they have sent the intent to revoke based on inability to pay. The employer mentioned this is a disregarded entity and they filed the personal taxes instead of the business taxes, the company. So he has given the documents for provided for inability revoke. So we thought that would be enough sufficient documents for them to get this through.
Yeah, no, that's not how it works. When you say disregarded entity, I can only assume you're talking about a Chapter S corporation. They don't
Yes.
import the employer's income into a Chapter S corporation. So I'm not quite sure what is going on with your case. But proceeding forward, I certainly think that you should have it assessed for the possibility of a lawsuit, because some things just can't be corrected through the Administrative Appeals Office. I would say 9 out of 10 cases we no longer file appeals. We just go to court.
Mm-hmm.
Okay.
Okay. Sir, another follow-up question on this. So we have our own LLC.
Mm-hmm.
If I can able to have the same job description and keep myself in this employment of my LLC,
No.
would that be
But you can't get a green
applicable?
card. You can't get a green card through that. Okay.
Okay.
So once your 485
sorry.
is filed, has been pending 180 days,
Mm-hmm.
and there's no challenge to it, it is reasonably safe to port
Mm-hmm.
over to your own corporation. We have some frequently asked questions on this. Listen to them, because we've dealt with this issue in great
Mm-hmm.
detail over the last few years. And, there are some risks in porting to your own corporation. But if the priority dates are not current, if they are trying to revoke your I-140, it certainly would not be a good option, because
Mm-hmm.
the entire 485 is under challenge. Okay.
Correct. Sir, if the EB3 is revoked and they can we still be having our status here, and can our EB2 date, which is 2011, can still be able to be getting us for our I-485?
No. What will happen is, if the EB2 date is not current as of the date you filed the 485, they will reject the 485.
Mm-hmm.
You are, of course, entitled to get your H1
Mm-hmm.
extensions. You may have to step outside USA to get H1 stamped. You can come back and wait for the 2011 date to become current and file 485 again. Okay.
So we cannot stay here and file. We cannot stay here then.
You don't have active H1s right now, do you?
Yeah. No, we don't.
Then you can't stay here.
It's been like 6 years, more than 6 years.
You can't stay here. Okay.
Okay. Thank you, sir. Thank you so much.
You're welcome. Good luck. Pooja says, my employer filed my green card in EB1 in 2018. I-140 got approved same year. L1 visa got rejected. So EB1 was approved. L1 got rejected. I have to leave US and move to Canada. My priority date has become current for the next steps. I have to file 485. I have to go through consular processing if I'm not in USA, but the employer is refusing to file. I assume you're saying 824. What can you do? Well, I-824 can be filed by you personally. I don't think you need your employer to do that. You can double check the form, but from what I recall, 824 can be done by you personally. Okay. *5 if you have a follow-up question on this, *5. Okay. Next one is question number 5. H-1B transferred, did a change of status from H-4 to H-1 in 2018. Working on that H-1B for 2 years, transferred to another employer, started working there. Can the old employer withdraw his H-1B? Not only they can, they must. It is required by law for an H-1B employer whose employee is no longer working for them to revoke the H-1B. They are required by law to do that. And that does not have any impact on the H-1B transfer. You already have the transfer approved. And the fact that the old employer was a change of status from H-4 makes no difference. So yeah, that's not a problem. Second, spouse is also on H-1B, but the I-94 expired last month. With extension pending with USCIS, time till October to respond, an additional 60 days. We applied for change of status from H-1B to H-4. Given the H-1B from a previous employer, that should not matter. You should go ahead and call the USCIS and ask them if you need to change the petition number on the H-4 request. I don't think you will need to, but you can double check. Okay. I think you'll be okay, because ultimately, if the old employer revokes or withdraws the H-1B, and there comes a time when the USCIS wants to know how you are maintaining status, they will send an H-4 RFE. At that point, you can provide a copy of the transfer approval. Okay? But call the USCIS, doesn't hurt to check with them. Make notes about what they tell you. Date and time the notes and who you spoke with. *5 if you have a follow-up question. Okay. Karan apparently is one of our clients. He says my H-1B was approved. Change of status was not approved because I had traveled outside the country. So now I've got the H-1B approval, but I don't have a visa yet. I'm still using my STEM OPT. Well, Karan, the easiest thing is to just apply for a change of status again. And we've done this before. It's like reapplying for an H-1 all over again. But there's no harm in it. So because the STEM OPT expires in Feb 2021, you can apply for a change of status premium processing as early as you like. I mean, I personally would do it about now or in a month from now. So that way you get a change of status and you could get converted to H-1B. You don't have to travel outside USA. *5 if you have a follow-up question. *5. Okay. Couple in the US. I'm a US citizen under lockdown. In India, I'm a physician working telemedically. Wife is a green card holder. Can you do a 319B? Well, the problem is your job is not one of the qualifying occupations that allow 319B. You're not working for the US government. You're not a missionary. There's a 5 or 6 point exemptions, and I don't think your job qualifies. Well, I don't know what the USCIS is going to do during citizenship because all of this is so up in the air. I think USCIS should have a policy of forgiving people's mandatory almost stay outside the USA for over 1 year. But right now, I don't think there is a choice. And I don't think you qualify for 319B. So you have to make your plans accordingly. *5 if you have follow-up questions, *5. Also listen to the discussion we have had, the very first discussion we had today about maintaining your green card when you're stuck outside USA. I think she's going to have the same problem. Okay, next question, number 8. My H-1 visa is expired without stamping from employer A, transferred to employer B. If I travel to get stamping and visa gets denied, can I still use my employer A expired petition to transfer to another employer? Well, that's not quite the way it works. But once you have been outside the quota, which means you received a change of status and you were in USA on October 1st of that year, or you had a visa stamp from outside USA, then you're exempt from the quota. So you're really not using the old employer's approval directly, but you're using the fact that you have received exemption from the quota, having been approved for both an H-1B and a change of status or a visa stamping in October 1st or after that in any year. So in other words, the fact that you received an H-1B approval, government says is not enough. I think they're wrong. They say you should also receive either a change of status or you should receive a visa stamping. Okay. Now, the first one, I don't know if you were in USA. Did you get a change of status? So it's highly conjectural because government says if you have not received a change of status or a visa stamp, you are still stuck in the queue, in the quota. I don't think you are, but that's what they say. *5, you can test it out by filing another transfer. Okay, next question, number 9. This is an arrest for marijuana. So this is a very complicated situation. I want you to talk to a lawyer wherever you are locally. So what happened was that many states decriminalized marijuana, but the federal government has not. So even though you have no problem under state law, you could have a problem, you will have a problem probably under immigration laws. On top of that, the fact that you were arrested has to be discussed. You can't just keep it out of the application. So when you file the N-400, you have to state that you were arrested. You don't have a choice. And I know that government has been trying to badger people into admitting their marijuana convictions during the N-400 interviews, which then becomes a good moral character issue and leads to a denial of naturalization. If you have multiple convictions, you could even be deported, even though you have a green card. So I think the smart thing to do at this point is wait and see what happens in the elections. Because if Biden wins, some of these really dumb rules are going to go away. Okay? So yeah, you can't keep that arrest out of the papers. You have to reveal to the government. *5 if you have a follow-up question. *5. Okay, we are now on to question number 11. I think this is what you're asking, Sureshji. I'm not sure if this is, oh, there is a follow-up question. This looks like a voice over IP. Yes, how can I help you?
Hi. So on the arrest, so even though that arrest is sealed and it's not in the public, that still has been submitted to the...
Yes, it still has to be, it has to be disclosed. Even if you got the record expunged, you still have to disclose. In immigration law, you do. Okay, in employment applications, you don't.
Okay, so even though, so if they run a check on that arrest and it doesn't show up, it doesn't matter?
Doesn't matter.
That it was,
it doesn't matter.
Not on record?
It doesn't matter.
Okay, so it won't be disqualified if I put it and it doesn't show up in their
that's
records.
not a problem. That's not an issue. But I think you should wait till January and see how the laws flow. Don't file right now.
Okay, thank you so much.
You're welcome. Good luck. Okay, so let's go back to, where was I? Yes, I think, Suresh, what you're asking me is that you were working for a company A in a managerial role, and you've been working for that company's parent for the last 10 years. Now the company A has only one active employee. A has only one active employee. That's the foreign company. Okay. The rest of them started a new entity. Okay. Okay, I'm not sure exactly the details of your question, but the basis of an L1 are not necessarily the number of employees. The basis for an L1 are transactions. So if the company is doing business and they have business transactions going on, they are considered to be in business. Whether they are making profit or loss also does not matter. Of course, the more the employees, the easier it is to prove your case. I wish you were here because I'm not quite sure what you're asking me. *5 if you have a follow-up question on this *5. Suresh, if you're here, press *5. Yeah, your question is a little vague. I'm not sure what you're asking me. So the number of employees is not key. It is the number, is the transactional activities that determine whether or not business is being done. Okay. Next one is from Rakhi. Working for a hospital on cap exempt H-1B, a consulting firm applied H-1B in lottery, got picked and approved. I have a soft copy of the H-1B approval. Can I transfer to another private company after October without working for the consulting firm? Yes, you can, as long as they don't revoke it before October 1st. So once again, without ever joining this company, you could transfer to another employer as long as this company does not revoke your H-1B before October 1st. *5, Rakhi, if you're here, if you have any questions, *5. *5, okay. Asylum, sorry, I have no idea. Belladonna, my apologies. Ashish has a question regarding EB1C category. Been working for an India-based employer A in India for 9 months. A has been acquired by a 20-year-old US company. Company B has applied for my H-1B. Oh yes, you will be eligible for EB1C category because you worked for a subsidiary or a branch, etc. of the US company for at least, yeah, but you got to work there 1 full year. You've been working 9 months. Okay, so you're going to come to USA after about 15 months of work. And it looks to me you will qualify for EB1C. Yeah, I don't see any problem with that because you can have this double checked, but the relationship between the companies does not have to be 12 months or more. It is just your employment that has to be 1 year. So in this case, because they acquired a company for which you have been working 15 months, 9 before they acquired, and 6 after they acquired, you should qualify for an EB1C from what I can tell. Okay. *5 if you have a follow-up question. Okay, well, there's another part of your question. I've worked in the US in the past with another company, C on L1 for 5 years. Does this 1 year period only start counting when I start my job in US? Oh, no. Well, first of all, you need to, I don't know what you are doing with your H-1B. If you are basing your H-1B on the, see, you've been outside USA for 1 year, haven't you? So you'll have 6 years of H-1B again. So I'm not sure. Ashish, are you on the phone? Press *5. Darn, guys. Well, I can't really, I'm not sure exactly what you're asking me. I can tell you generically the law. If you've been outside USA for 1 year, you're entitled to all 6 years of your H-1B, but you have to go through the quota. Okay. So you can always come on an L1. Why do you want to come on an H-1B? And that's another thing I don't understand. Come on L1, and if you've been outside USA for 1 year, in your case it will be 15 months, you have 7 years of L1A again, right? *5, if you have a follow-up question, I don't think you're here. *5. So this question is from Deep Mact. My spouse I-140 was approved 3 years back. They didn't give you a copy. You are filing a Freedom of Information Act request, but you have the receipt number. Good. I'm working on H-4 EAD, good till 10 months from now. The new employer is telling they need approved I-140 copy, not receipt number. I guess they want to extend the H-1B. They should be able to get the H-1B extended with the receipt number. We've done it in the past. Okay. Does the new employer have to start her green card? They have to, because if she wants to get a green card, right now she just has an I-140 approval under EB2. So she will have to start her green card again, but it will carry the priority date of the old case. Can my employer file green card for me? Yes, even though you've been on 7 years of L1A and you are now on H-4 EAD. Why not? Can they apply for an H-1B? I believe so, because then you would be entitled to your extension beyond 6 years. Well, actually, hang on. You've never been on H-1 before. You've always been on on L1A. So I'm not quite sure how that would work. I don't think there is any law or policy that covers that situation, where you finish 7 years of L1 and then you are entitled to H-1B extension because of green card, but you've never had an H-1B before. Can you go through the quota? I have my doubts. I don't think you can get an H-1 extension. I'm not sure what you're asking me. This question is quite convoluted. Are you on the phone? Press *5. Okay, so let's see if I can understand what you're asking me.
So you are asking about question second or
where are you calling from?
I'm from Dallas.
Okay, so Dallas, you are saying once our H1 H4 EAD is approved for another 3 years, can we go out of USA for 1 year and I can start working for same H4 EAD? I don't understand.
So let me phrase it. Right now our EAD is valid till next year.
Okay.
So everything goes right, and our employer filed for the extension, so we will get for another 3 years, right? H1 will get extended for 3 years, and H4 EAD will also get extended for 3 years in best case scenario. So we will have the H4 EAD and H1 valid till somewhere in the 2024, right? So because since as for the question second, since I have never been on H1, I cannot, even my 140 got approved, I have to be outside the US for 1 year.
I'm not sure how that will play, but it looks like it.
In that same scenario, since I cannot apply for H1, so another thing we are thinking, let's wait for another 1 year when our next visa got approved for 3 years, then we'll go outside for US 1 year and say we are coming back somewhere in the 2022. So by that time our 1 year outside over, my wife's H1 is still valid for another 2 years. And my H-4 EAD, I'm not sure if you go outside, our H-4 EAD will be valid or not. So if our H-4 EAD is valid,
okay, now
we can come back.
You're making it even more confusing. I'm not following you at all. So let me answer to you this way. If somebody has an H-4 EAD, which is good for 3 years, if they are outside USA for 1 year, can they still come back and use their H-4 EAD? The answer is, I think so, yes. As long as the H-1 holder still has the same job or maybe even another job, I think there it gets doubtful. But my guess, I have to look at the entire body of laws to kind of figure out if there is anything that's stopping you from using that H-4 EAD. But just because you've been outside USA for 1 year, during the validity of your H-4 EAD should not stop you from being able to use it when you come back. Okay?
So my only question is, if suppose right now my wife is working with H1 employer A, we go and come back with employer B, we change the job. In that case, the only scenario.
I have a little bit of a problem with if both of you are outside USA, when she applies for an H1, I think it's a little bit more problematic. If she comes back and works for the same employer, I think it's a little bit more clear cut. I have to, again, I said, look at the law. I don't know exactly how it works. If you leave USA and then she changes to employer B outside the USA, can you still use the H-4 EAD? I do not know. I have to check the law on that. Okay?
Okay.
Good luck. Oh yeah, the one other thing was spouse's attorney used only first and last name. Does it create an issue in the future? Well, I don't like to keep those discrepancies. As long as the H-1B was issued under her full name and that's what she uses. Okay. Is this your first name, middle name, or is it hers?
Hers only. Okay. So like her middle, they have used her new attorney, because our passport had only last name and first name. Whatever there in the first name, everything is included in the first name of the petition. But all our old documents, her middle name is there.
I don't think it's gonna be a problem in the immediate future, but do keep everything consistent. Somewhere along the line, if you want to align your passport name with all the other documents, might be a good idea. And then all the subsequent H-1Bs, green cards can be filed with that full name. So in the immediate future, no problem. I think ultimately, it should all be brought in line. Okay.
Yeah. Overall, full name is same. Only thing the middle name and first name is broken in.
Yeah, I think we should be okay. I think we should be okay. All right.
Thank you.
Good luck, sir. Now, Neil wants to know about salary reduction on H-1B. Salary was $65,000, then it got reduced by 13%. They didn't file an amendment. We agreed on showing unpaid leave. That doesn't work. That doesn't work. That's actually could end up being called fraud. So the last word we had from the Department of Labor, as far as I recall, was that as long as your salary meets the LCA wages, okay, I want to say the prevailing wages actually, prevailing wages shown on the LCA, they will allow this to slide. So let's say the H-1B salary or the offered salary on the L1 was, or on the H-1 was 65,000, but the prevailing wage was 55. A 13% reduction should be okay. Okay. So other than that, I don't know. If you can answer this question, if after reduction by 13%, do you still meet the prevailing wage, you should be okay. If not, you're out of status, and don't do any of this this stuff like unpaid leave of absence and all that doesn't work. Okay. you will then have to at some point correct your status by going outside USA and coming back on a visa. *5 if you have a follow-up question. *5. Okay. Next question is about, can you please be a little bit quicker on hitting *5? Because I got to keep going back to the questions you have. Area code 972, go ahead, please.
Yeah, I'm a different person. I have a follow-up question. So if our LCA has a salary mentioned, say, 70K, but if they give salary 85K, 80K, will it is okay? Or
yeah, more is
always, giving more salary.
More is always okay. Okay, more is always okay. There might be other issues of parity with other H-1B holders, etc. if you're getting paid a lot of money. But we've had cases where the base salary was 75,000, but the bonus was 65,000. Or the bonus was, one of our cases of a Wall Street banker, investment banker, was close to $600,000. So that can happen. Even for physicians, we have seen that the bonuses are very high, even though the base salary is low. So that's not a problem. If the LCA says 80,000 and you get paid 120, that's okay. All right.
So LCA they may mention 80, but salary say 90. Or offer letter also say 90. So there should not be any discrepancy, right? Because
no, that's not really a discrepancy. That's just their offer, and I think that's okay. If you're getting paid 90,000, you're all right. Okay.
Thank you.
Welcome. Bye-bye. Okay. Then the next question is from Tim. Wow. That's a long. Oh, yeah. So you have a U visa issue. Your case for adjustment of status is getting delayed. Congressman. Okay, you contacted the congressman. Case transferred to the NBC. There are some delays because of unresolved issues. So when was your 485 filed? 2017. Maybe a good idea to explore the option of a lawsuit. I understand there's a U visa stuff. No, I don't know if you should withdraw. I think you should definitely explore a lawsuit in Dallas. I think you said Dallas somewhere. No, LA. Okay. So it may be LA. So wherever you are located, you can talk with a litigator. We file many of these cases out of Washington, D.C., but D.C. is not appropriate in every case. When there's a local dispute, the government and the courts prefer that it be kept local. When there is a policy issue or there's an issue that concerns the federal government, we can easily file in Washington, D.C. It's not a problem. But in this case, I think you're better off with the local court. And yeah, do look into filing a lawsuit. *5 if you have a follow-up question. *5. Okay. And this is the last question today. We will not have time for any new questions. I filed for green card under EB-1C in 2018. With approved I-140 and 2 years due to company layoff, I lost my job. Using AC-21 portability, moved to a new employer in similar role with my valid EAD. Okay. This month, my I-485 and old I-485J got approved. Which one was your old I-485J? Because I see only one I-485J in August 2020. Who's raising their hand? Guys, please be quick about raising your hands. This is a little difficult. So stay on the line. Let me just finish this first. To leave my employer, my old Y-45J got approved. A new Y-45J is still pending. I wouldn't worry about it because as long as you have filed, And the fact that you have a track of same or similar jobs is good enough. What I would do if I were you is I would let the local office in Texas or wherever the other case is still pending, the 485J, I would call them up and say my green card has already been approved. So go through the customer service and let them know that there should be no 485J pending any longer. Make sure you keep copies of all your documents, including the 245Js, so that if it ever becomes an issue, you have a complete copy of the paperwork. Also make a note of your discussions with the customer service, the date and time you called, what they told you, etc. I don't think of this as a big problem. *5 if you have a follow-up question, *5. I'm going to go back to area code 512. You should press *5 again, because if you press *5, you get taken off. Okay, here we go. 512, where are you calling from?
I'm calling from Arizona Channel, sir. Good afternoon.
Good afternoon, sir. Tell me. What is
so should I do like a service request and follow up for the latest 485J to be approved by giving the details of my green card?
Yeah, what I would do is, because your green card is already approved, you should let them know that the 485J can now be put to rest because you already have a green card approval.
Okay. I just told to my company attorney, but they said, no, you have to wait for 3 months to do a follow-up. So that's the reason I'm a little bit in dilemma.
No, it's not a follow-up. It's not really a follow-up. You're not trying to check the status of the 485J. You're just telling them that you received your green card, so the record should be updated.
Okay. The latest one also, they should approve it.
Approve it or whatever they want to do with it. Don't really care. You filed it, you've done your job. What they want to do it is their business. Okay.
Got it. So, thank you.
You're welcome. Good luck.
Thank you.
All right, folks. That's it for today. It's good to talk with everyone. I'll see you again in 2 weeks. Be well. Stay safe.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.